You're on the floor of a grocery store. Your lower back and your hip are killing you. An employee rushes up to you, but the first things that he says is not, "Are you okay?" It's, "Hey, let me help you up." That's not employee kindness. That is company protocol. Because as soon as you stand up, that mess gets cleaned up before anyone ever takes a picture. And your best evidence has now disappeared. I'm Max the Axe, the gold standard in personal injury. And what you do in the first 10 minutes after a slip and fall accident in Texas could be the difference between your claim surviving or dying. The store already has a plan. You need one too. You stay, you take photographs, you talk to people, and most importantly, you save everything. That is the sequence. Let me walk you through it. Because by the time you get home and you think about calling a lawyer, the floor is now dry, the videos are aging and are not being preserved, and all of the witnesses are gone. The first 10 minutes matter more than anything. Now, the store's corporate risk team has handled hundreds of these accidents before. They have a plan. You need yours. The first step is stay exactly where you are. Don't get up and try to walk it off. Don't wave people away. Don't let the temporary feelings of embarrassment override your need for self preservation. And if you're in serious pain, don't move. Ask someone to call for medical help. Step two, talk to someone. Don't just say, "I'm fine," if you're actually feeling pain. Do not apologize if you don't know what happened. The employee who rushes over to you is not your advocate. The employees are often trained or at least encouraged to de escalate the situation as much as possible. Their job is to make sure that everything appears to be minor and small, not an issue, minor injuries, no big deal. Your job is to make sure that everything is documented. And here, the most important words out of your mouth should be, "I need to speak to a manager to file an incident report." Step three, take photos. Before you stand up, take out your phone, turn on the camera app, take photographs of everything in the area. Take photographs of what you fell on, whether it's a spill or grease or a broken tile or an unmarked wet surface. You want to make sure that you document as much as possible. Don't just take one or two photos. Take as many as you can from different angles. Was there a wet floor sign? Was it visible from where you were walking? Take wide shots and close-ups. This process may take about 60 seconds, but it could make or break your entire case later. Let me tell you about Diana. She slipped on a puddle of condensation from a refrigerating unit at a local Houston grocery store. She was able to photograph the puddle and the missing drip pan from underneath the refrigerating unit. In the photos, you could see that it was just this one refrigerator that was causing the leak. The ones next to it were fine. By the time she got to the emergency room, that floor had been cleaned up and the drip pan had been replaced. And the photographs that she took were the only evidence to prove the hazard ever existed. And here's what the store is counting on, that you're too hurt or too embarrassed to document the scene. So here's what to preserve. It's not just the photos of the hazard, the surrounding areas, of your visible injuries if you have any, but you also want to keep track of the names of every employee that you speak to, as well as any independent witnesses who may have seen what happened. It's so important to get their contact information then because they disappear later. The incident report. Get it before you leave. Finally, save. This is the last step in the sequence, but it's also one of the most important. Report the incident to a store manager and make sure that you get a copy of the incident report before you walk out of the door. Make sure that the incident report keeps track of the date and the time that you fell, as well as the description of the hazard and what caused you to fall and exactly where in the store this took place. You also want to make sure that you get the manager's name on the incident report and any description of your injuries, what parts of your body are hurting. You want to keep it as brief and factual as possible. What you saw, what happened, and what hurts. But don't try to speculate about who's at fault and the extent of your injuries. Here's what most people don't realize. The store's form is designed to protect the store, not you. Their version of the events might describe the floor as damp when you saw a full puddle of water. Their version of the incident may say that the customer reported a fall instead of identifying the number of witnesses who all saw the fall happen, even when one of those witnesses is a store employee himself. The way that they choose their language in the incident report is designed to say maybe a fall didn't happen, Or maybe nothing was ever on the ground, despite what the evidence may show. If you can, ask for a copy of the completed report. If they won't let you have one, you can take photos of it with your phone. If they refuse to create a report at all, which also sometimes happens, make sure that you get the manager's name, the time, and exactly what they said. You can also pull out your own phone and record who you're talking to. If you can get their email or contact information, you should preserve everything in a letter or a text message or an email that documents everything that happened on that day. If they don't want to create an incident report, you need to preserve the evidence as best you can. Make sure that you send that text or that email or that letter on the same day or the day after. That email or text message is time-stamped and can be used later as evidence. So here's what you demand: a written incident report with the manager's name, the date, the time, and a description of the hazard, and get a copy before you leave. Surveillance footage window is closing. And if you do nothing else, do this. Tell your attorney about the surveillance cameras. Most retail stores run their surveillance on a loop, and this records over itself every 14 to 30 days. Some smaller stores may recycle the footage even faster. This means that the footage of your fall, the single best piece of evidence that you can have for a case like this, gets overwritten every 14 to 30 days. This means that the footage of your fall, the single best piece of evidence you can have for your case, has an expiration date. Your attorney can send a special letter called a preservation letter that lets the store know that they need to preserve that footage. However, that letter only works before the footage is recycled. But here's what the store is betting on. They're betting on you waiting to hire an attorney. By the time the attorney gets the case and sends the letter, the footage is gone. And at that point, it's now your word against the store's word about what happened on that day. And they have a full risk management team to fight against you. This is why timing matters the most in a slip and fall case, way more than a motor vehicle accident case. In a car crash, there's an incident report created by the police officer around the same time that the crash happens. But in a slip and fall case, evidence might disappear after a certain amount of time. Here's what to demand: a preservation letter that is sent to the store within days of your fall, not weeks. The one word that decides your case: notice. Texas law does not hold the store liable just because you fell at their store. The store has to have either known about the hazard or should have known about the hazard before it happened. This is called notice, and there are two different forms of it. Actual notice is where a store employee actually knew about the hazard before you fell. Either an employee saw it or somebody reported it to them. The other type of notice is called constructive notice, and that's when the hazard was on the floor for long enough that the employee should have known about it. But here's the trap. The store will always argue that the hazard was on the floor for only a few seconds before you walked through it and fell. And if you can't show through your evidence that the hazard was on the floor for longer than just a few moments, then they win. They will argue that since it showed up just a few seconds before you fell, that even with a reasonable inspection, they would have never caught it in time. And that's why the store's inspection logs matter a whole lot. Many large retailers require their employees to do sweeps every 15 to 30 minutes. And if those logs show a gap, for example, you're supposed to be sweeping through the area every 15 minutes, but it shows that it took you 2 hours in between sweeps, that is evidence of constructive notice that had you followed the store protocol, you would have caught the hazard in time. Your attorney will need to file a lawsuit to get these logs because the store will not give them up unless you file a lawsuit. So here's what to demand: the store's inspection and maintenance logs for the day that you fell. The defenses the store will use against you. Every major retail chain has a defense playbook, and it starts before you ever talk to a lawyer. Defense number one, that the hazard was open and obvious. They will argue that because the spill was so big that you should have seen it and you should have looked out for it. But this defense is weakened when you highlight the conditions that the store created that make it difficult to see. The polished wax flooring that makes the floor appear clean can also make it very difficult to see when the overhead lights are shining directly on it. Additionally, the store also has marketing displays right at eye level to keep your attention while you're walking through the store. And so unless there's a big orange cone right next to where the hazard is, you're not going to be looking down at your feet while you're shopping in the store. Defense number two, You weren't paying attention. Were you on your phone? Were you looking at the shelves instead of looking at your feet? Texas proportionate responsibility only means that they need to prove that you were at least 50% responsible for the fall. And if they win that argument, you recover nothing. Defense number 3. Your injuries must have come from something else. If you don't see a doctor quickly after the fall, the insurance adjuster will argue that maybe it was something else that caused your injury. And the gap between the day of the incident and your first doctor's appointment is one of the easiest tools that insurance companies use to deny your claim. So if you feel that something is wrong with your body, that you feel achiness, stiffness, or something just doesn't feel right, it's important to document your pain at an urgent care, emergency room, or primary care physician. Oftentimes, pain from a fall doesn't show up until a couple days after the incident, and by that point, the insurance adjuster is already building their case to argue that something else is responsible for your pain. And one more thing before I finish up this video, stay off social media. As soon as you file your claim, the insurance company will be going through your public social media accounts, and what they're looking for are activities such as going to the gym, going on vacation, or anything else that's physical with your body. They will be arguing that because you can do all these things, if you can go to Disney World or you can go work out at the gym, well, then that means that you must not be that hurt. The safest approach is just to stay off social media entirely until your case is closed. The adjuster is also counting on you giving a recorded statement to the insurance company before you ever hire a lawyer. Anything you say about what you were doing, where you were looking, or how much you saw the hazard beforehand will be used as ammunition against you later. Here's how you protect yourself. Get to the doctor as soon as you feel that something's not right. Stay off social media and don't give a recorded statement. The biggest mistake that people make with slip and fall cases is that they feel like they have so much time. The footage is already aging, the floor is already clean. You don't have that much time. Remember the sequence. Stay at the scene, talk to someone who matters like a manager, take photographs of everything in the area, and save a record of as many things as you can. And if you slipped and fell at a store here in Texas, whether that's a Walmart, a Kroger, an HEB, or anything else, give us a call at Lone Star Injury Attorneys to talk to us about your case. We handle slip and fall cases from Sugar Land to Houston and all throughout Texas. And one of the first things that we do is we send that preservation letter as soon as possible to the store so that we can start preserving the evidence today. One more thing. In Texas, you generally have 2 years from the date of the incident to file a lawsuit. Now, that might seem like a whole lot of time, but evidence can disappear between the date of the incident and the time that you file the lawsuit. It's important to talk to a lawyer as soon as possible. The sooner you act, the stronger your case will be. And also, go watch my video on premises liability in Texas to get the full legal picture behind what a premises liability claim is and what it isn't. I'm Max the Axe for Lone Star Injury Attorneys, and we fight for injured Texans.